Shall I just continue though, or?
No, they didn't hear anything.
Nobody can hear anything. All right, I'll just be a moment. Excellent. So I hope that everybody can hear me now. Sorry?
We have 20 people online around.
Excellent. Fantastic. All right. So I just went through. Hi, how are you? Texie, you're very welcome. You're okay. You're okay. We're expecting a few more people coming in, but we've got lots of people live and streaming, so I'll be talking to you together with them. Excellent. All right. So what are we talking about today? Today we're going to look at how to protect your brand and your ideas, products or invention. So why is it important to protect your IP? We're going to look at the different type of IP protections that exist in the UAE and more globally, how to register and your IP, and employee and contractors. So what are some of the considerations that you need to make when you're, for example, hiring a CTO or outsourcing the development of that technology to, say, a contractor or developer? And then, what agreements do you need to put in place to protect your IP and to ensure that it is the company's or the founder, if you're registering in your personal name? So, protecting the brand of your startup, why is it important? So clearly when you're a startup, you're bootstrapping most of the time, and you're very conscious about where your money is going. And it's not the first thing that you think of doing, protecting your IP, because when you look into it, particularly in the UAE, it's a little expensive. However, IP, in particular in technology companies, is probably one of the most important assets of your company. And so it's very worthwhile considering and exploring how to protect your IP, even if it's just starting with a basic trademark, copyright for those that have platforms and can protect with copyright. And then, of course, patent might be something you look a little bit down the future and takes much longer and is more expensive. But at least as a minimum, to start with trademarking the name, the logo, the brand, the domain, and things like that. All right, so the types of protections and then the definition. So already discussed it very briefly, and I'll go into a little bit more detail with the definition, but we've got trademark, copyright, and patent, and they're quite distinguishable. So if you've registered a trademark, it doesn't mean that you're protecting your copyright, and it definitely doesn't mean that you are protecting a patent. They are different registrations, there are different filings and different costs and processes and procedures associated with those different IP registrations. So trademark, your most valuable IP. Why? Why do you need to trademark? Well, for one, it gives you business security. Asset increases your brand values. It's the credibility of the company, and essentially protects the registered name of your brand. So if you've gone and thought of an amazing brand, you love your logo, you love your design, you love your colors. I mean, let's just think of McDonald's, right? You think of McDonald's and you think of the M, you think of the yellow, you think of the red. You could absolutely not think of McDonald's any other way. That's their brand. That's how they position themselves. Everything about their style, of the wording, of the language, of the logo, of the slogan, we know about McDonald's, and they spend so much money building that brand, so they protect it. And same thing with a startup. If you've thought of a name, you've thought of the colors, you've thought of your design, you don't want anybody coming out and claiming that same design or color or word or logo or sound or scent, then you want to protect that. And you can do that through a trademark registration and filing. So what can actually be trademarked? Essentially, a trademark is for a mark. So when we're thinking of a word or a name, a logo, it could even be a sound, a movement, a scent, or a color. So a lot of people don't think that they can register a trademark, and they don't think it can be a scent. But in fact, if you're a perfume company and you have an original scent, you can trademark that scent too. And the colors, of course, of your logo, the wording, there could be movement, and there can even be sound. So if there's a specific sound that's associated with your brand or name or logo or your slogan, you can also trademark that. And so what this does is it distinguishes your business from your competitors. But not only does it distinguish it, it also protects. Because once you've filed a registration of that trademark, then you're protected for a number of years, and we'll talk about that more specifically. Actually, it's right over here. I'll talk about that now. So once you've registered your trademark, you are protected for 10 years. Of course, it's renewable after that period, but at least once you've registered, you know you've got 10 years, you've got the right to use it, authorize the use of it, and also stop the use of it by anybody else. And that's really the point of trademark. To enforce your right against anybody who potentially might come along to copy that. Okay, so I'll talk in a minute again about, yes, say again, yeah?
So I just ask a quick question.
Yes.
I assume the trademark, though, is just on a national level, right? So, I mean, if you had a case where perhaps someone's imitating your trademark in Saudi, you know,
Very good question. So we were just going to come to that on this slide. No, absolutely. But I can jump to and answer the question. So the question was, if I trademark in one jurisdiction, for example, Saudi, does that protect is my mark protected globally or across different jurisdictions? And the answer is no. The answer is that you need to register your trademark in separate jurisdictions in order for it to be protected in that jurisdiction. So if you're in Saudi or you're in the UAE or Qatar or anywhere in the Middle East or US or anywhere for that matter, and you've registered in that jurisdiction, then you're not automatically protected everywhere. So on that point as well, what they did was, obviously there's lots of startups who are doing business and want to protect their trademark in multiple jurisdictions. So what they came up with is the Madrid Protocol, and I'll just jump to that and come back. Now, what the Madrid Protocol is a set of countries that have signed the protocol and just made it easier for, say, businesses and startups who want to trademark internationally. Now, the Madrid Protocol doesn't say if you've signed the Madrid Protocol or you've registered under this, you're automatically registered globally. All it's done is it's streamlined and allowed one platform where you can go to pay. Hi, Rifty, how are you? To pay in order to, sorry, I've lost my train of thought there, but I think what I was saying was, so the Madrid Protocol is just simply a protocol where there's a portal, and you can go to that portal to try and register your trademark in multiple jurisdictions rather than just the one, because otherwise the normal procedure is to go to the Ministry of Economy or the authority in the relevant jurisdiction and independently file and register, whereas with this portal it's now one spot that everybody can go to, and then check what the formalities are, check that you're satisfied, and you satisfy that country's trademark office, and then you pay, and once you've applied you get a certificate of registration if the mark complies with that jurisdiction's law. Okay? And UAE is part of the Madrid Protocol, yes. So if I just jump back to, what can you expect when you are trademarking in terms of what's the procedure, the length and the cost? It generally takes up to 3 or 4 months. It's around about 9,000 dirhams per class, and that's just the authority and filing and registration fees. So that's not professional fees for the trademark company or agent or lawyers that you're going to use. The prices also may vary, so you need to check at the time that you're trademarking what the updated fees are in case they're updated by the authorities. Essentially, in a nutshell, the process is to file an application with the relevant trademark office in the jurisdiction. You need to share a set of documents, so the logo, the brand, the name, the slogan, the ID. You would actually need to give samples of that to the trademark office for their evaluation. It's actually published in the official Gazette. So the reason why a trademark or any IP is published publicly is to give the right to others in the market who have a claim or right to that, to object to the filing of your trademark. Now, the concept of trademarking is really on a first come, first serve basis. So if I, for example, let's look at Legal Circle logo here. I think it's quite catchy. I really like it. I haven't trademarked it yet. We need to. But let's say I go to trademark this, okay? And I go to the office and they say, right, fine, thank you for the logo. Now it's in the official Gazette. And they put it there for 30 days. And somebody before us has already a very, very similar logo with similar colors in the same class registered before us, then that would stop us from being able to register that. So it's a first in, first served basis. I cannot come along and say, but hold on, I've been using this logo for a lot longer than what they have. The idea is, when did you register? Because the person that's registered first in time has priority. I can object, however, if they've registered but not used the trademark, logo, name, brand for more than 5 years, and I can prove that. So if somebody's just registered for the sake of getting in first and getting in early, and they think, oh, now I have a protection, but they never bother to use it. No, they don't use the name, the brand, the logo, the scent, the color, whatever it is that they've trademarked, then I could potentially object to that when it is published in an official gazette. I can object to their filing and say, well, they've not used it. Obviously the trademark office will need to make an assessment and evaluation, but they will do that, right? So they will look at whatever oppositions are made before official registrations.
Great. Would you like to take questions now, or you want to keep it there?
I can. If the questions are relevant to what I've just spoken about, happy to take it, just so I'm not jumping too far ahead.
Yeah, can we register a trademark in the UAE as a foreign company, or do we need to be established locally for this? So it's related as well.
Great. So shall I repeat the question just so that they can hear?
Coming from online, so
Okay, so everybody can see that. Great, fantastic. So the answer to that question is, you can be a foreign company and register your trademark in the UAE. You don't need to be set up or incorporated in that jurisdiction, and that's how trademark works, right? I could be here, but I want a global protection. The onus is on me, or the responsibility is only on me to register in each jurisdiction separately through the relevant trademark office, but it doesn't mean that I need to physically be operating or have an office or incorporated in that jurisdiction. So I hope that's clear. Yeah. Any other question?
yes.
Sure, ask away. I'm just going to have some
My
water.
question is for online training and mentoring company deciding data science that is registered in USA. What trademark option are?
Excellent. All right. So good question. So the way trademarking works is that you need to trademark your logo or name, brand, color, whatever it is, the trademark, into a predetermined class. Now those classes are found on the trademarking office websites. They will give you a description of the class, and that description will allow you to know and identify exactly how you're being and what class you're being protected. Let's take, for argument's sake, you're an online platform, and your online platform is a marketplace. You would trademark, and Rifty, you could probably give me what that class is for an online platform that's in a marketplace. Okay, so let's example class 35 says this is for online marketing, platform, any software, and there'll be a whole list of, or exhaustive description of what can be protected within that class. So what you really need to do is identify what is your business, or what are you actually protecting, and then what class. So let's say, for example, McDonald's, they would be protecting their brand in the class that protects food, beverages, takeout, fast foods, everything that relates to the food and beverage industry. And there could be multiple classes, or there may be one. But the onus is on you to actually go through, or your advisor to say, these are the different classes that you should go and be protected in. Because why is that so important? If you protect yourself in one class but not in another that relates to you, and somebody else comes along, they can protect in that class. They may be stopped from the class that you're protected in, but not from the other. So if you want to make it bulletproof, you should look at all the classes that relate and protect your trademark and register in those classes. So we've done, for example, up to 4 or 5 classes for any one client. Obviously, it comes down to the budget as well. It's not, it's not the cheapest process and procedure. So if you're bootstrapping, what you might do is say, okay, my most priority class right now is class whatever, and protect yourself there. And then as you raise funds or your revenues increase, etc., then protect yourself in the other classes. Yeah, fantastic. Any other questions?
Yes, but we will never finish, so I prefer...
Oh, we'll never finish. Okay, so we'll come back to you. For those that have got burning questions, we'll definitely come back to you. And I'll try and get through my presentation quickly so I can answer all the questions as well. Okay, so how do you register a trademark? Again, trademark office, it's the name, the logo. You have to provide what the classification is, the class. Sorry, I didn't mention that it's the NIS classification. And so it is a global classification. And that's why it kind of makes it as well easier for you to go through that process of what class and where and what jurisdiction that you need to be trademarking in, and then of course the details for the owner of the trademark. On this point, I want to make a very important point, and that is, when you are trademarking, you need to specifically identify who the owner of the trademark is going to be. So is the owner of the trademark you as the individual founder, or is the owner of the trademark going to be for the company? And the common mistake that people do is make the trademark be in the name of the founder. So they associate and attach it to an individual rather than to the company. Now, when you are a startup, particularly of a technology company, your IP, your asset, your brand, your everything that you're worth is not you as the founder. It's not you as a person. As much as you'd like to think you're super important, you can trademark and own everything, it's the company, because the idea is that the company is going to scale, fundraise, either go IPO or be liquidated and be bought out at some point by either merged, acquired with a massive giant in your industry. And so any investor who comes in is going to want to see that trademark belongs to the company that they've invested in, and therefore they own part of the IP. Remember, IP is what is valuable. IP is an asset in itself, which is why you're going to the extent to register and protect. So my advice to most of you, and if you're having investor issues or founder issues, if you're not sorted out what you're doing, you can put it in your name to begin with, but perhaps think of what point you're going to then assign that to the company. And I repeat, because I know that this is a lot of, particularly for startups, it's a consideration that weighs heavy. You will need to pay double the fees. So you'll pay for registering it in your name, and then you will pay the same amount to assign the IP back to the company or anybody else that you want to. So just a consideration for the startups who are bootstrapping. All right. I think I've covered that. Let's go. All right, protecting your trademark. I already talked about this Madrid protocol. So unless there's any questions, I'm going to move through. Protecting your trademark. So it's best practice. Again, the responsibility is on the owner of the trademark to be aware and keep an eye out on anybody who's infringing it, yeah? So the trademark office won't have a Google alert saying and waiting for somebody to come along and infringe my logo and my notice. It's up to me. So I should have Google alerts to keep on track if my trademark is being used without my permission. I can search an IP database to see if there's anybody who's got pending trademarks. And then just generally, if you're competing in an industry, I guess you will keep your eye out on the competitors to see if they're doing more or less the same. I'd have to say, most likely, when you're in that space, you'll come across if there is a competitor using it, but we haven't had, it doesn't happen every day, right? It's not something that's a very common occurrence, but it has happened. It has happened.
I have a question a little bit further.
Sure.
So do you advise to trademark an idea or wait until
Hi,
it
welcome.
gets traction, early stage MVP? So we save the cost. So the question is about like trademarking an idea or something still in the idea stage, not something that has been validated or approved the concept has.
Okay, interesting. So, I'd need to know a lot more around that in terms of, Is their ID such a novel ID that even before they've developed an MVP, for example, this is something that's going to be, down the line patentable, then I'd start the process, right? Because even, for example, with a patent, it takes a number of months. It actually takes almost, a few years. So you want to start that process. But generally, like, let's just say we're just talking about trademark, or just talking about a copyright. No, I'd wait. I'd wait because, you're probably, and I know with startups from our experience, change things over time. As they develop their ideas, as they develop the concept, their trademark changes. So until they've got a really good idea of what that looks like, I wouldn't I wouldn't recommend them trademarking or say copywriting. I'd wait till they had something that was a little bit more concrete, particularly when they're bootstrapping and cost is a major consideration. Okay? So what to do when a trademark right is infringed? Well, that's you've got to start a case. So the first thing you would do is send a cease and desist letter. So you'd approach your lawyer, or if you had an in-house, you'd send a notice and say that we've noticed you've been using a trademark, and here is our evidence that this mark is already trademarked in that class. So we ask you to cease and desist. That means basically stop, alert. If you continue, we're going to take this forward and try to seek damages. So once you've sent a cease and desist letter, and what you should include in that letter is details of the trademark ownership, any particulars of infringement, and then ask them to rectify the infringement immediately. If it's not rectified and they continue to use it and they just don't cease and desist, then you have a case that you can file in the courts against them. Again, court proceedings are usually a last resort, but essentially if they don't respond to your notices for them to cease and desist, then the process needs to be, I guess, pursued, and the only place to do that is the courts to get any recourse or any damages from them. Excellent. So that was on trademarks. Unless there's anything else on trademark, no questions? All right, perfect. I'll move over to copyright now, because copyright, again, is another form of protection for your works. And it's a little bit different from trademark because it doesn't, you're not protecting the same thing. A copyright and trademark are not the same, yeah? We talked about what a trademark was, a name, a logo, a scent. Copyright is more content. So it's more around a computer program or artistic drawing or content of a write-up. So most businesses will own a copyright, whether it's a written content, a website, marketing, software developed in-house. But what we find is most commonly is nobody will go and copyright, for example, their marketing material. It happens, but not as common, or their wording on the website. What they would normally go and actually pay to copyright is if they've developed a software in-house. So if you're a developer or you've got in-house development, what you want to do is copyright that development. So it's super important to do that. And it's not so expensive as trademarking, and I think it's really something that's important to do, because remember, it's your platform. It's essentially a lot of the platform tech companies, it's all about their platform, the design, the look, the feel, the content, the user experience. So you want to copyright that, the computer program.
Slogans
Yeah.
or taglines, would that fall under copyright?
No, slogans and taglines under trademark. Yeah. So benefit of registering a copyright, again, having the right to use and exploit your creative work for economic gains and ensure that nobody else is infringing on that and uses it to their own benefit rather than yours. So the protection is actually for 50 years in the UAE. So, you can see in contrast with trademark, it was only for the 10, the copyright is for 50 years. And we've got an example here, but for example, like if you're a songwriter, a singer, whatever, it would be, an example of a copyright would be the lyrics to the music, for example. But mostly what we see in the UAE, particularly with the startups and tech companies, is always the computer program or the platform that they use. Okay, so what do you need when you're copywriting? So you will need a power of attorney, and that's just so that the agent can go on your behalf and make those copyright for you. But the most important thing, I guess, from here is the incorporation certificates, trade licenses, hard copies of the copyright catalog. So you'll have to have actually a flash drive with all of the information on that flash drive. That flash drive then becomes protected. It's confidential. Nobody other than the trademark office will open that in order to register the copyright. But I have a lot of startups have a big issue with that. They're like, they're giving it to us, but they really don't, because now we've got their copyright program, but we don't look at it. We keep it, and anybody that takes it from you should keep that contained and give the flash drive over to the copyright office. But essentially they will need a copy. They'll need to see the computer program, they'll need to see the content, they'll need even instructions from you on how to use the platform and the program. So they'll need written instructions on that flash drive as well. So we've got lots of startups who want to copyright but are super nervous about giving this information. I'm like, but if you don't give it, we can't copyright. So excellent. So that's the copyright. We didn't have the cost in there, but it's not as expensive as the trademark, as explained, and it's not as lengthy. Rifty, copyright takes, as opposed to 3 to 4 months for the trademark?
About 1 week to 3 weeks.
About 2 to 3 weeks, yeah. I think 1 week is a bit ambitious because you're relying on the copyright office or trademark office to go through the process. But yeah, and unlike the trademark, the copyright doesn't need to go through the procedure of the official gazette and waiting for, you know, somebody to be put on notice to say, hey, we've got that already protected. Yeah, it's already assumed that that's different, that you've created that content and that you've not plagiarized from anybody else. So patents are, again, different from trademark and from copyright. What is the major difference between a patent, copyright, and trademark? And the major difference is that the invention needs to be so novel that there is nothing in the market, in the global market, similar to what you've created. So it's so unique. The test and the condition to the patent is this idea of being novel or unique. Yeah? So why do you want a patent? Well, actually, patent is probably the most, I mean, this is where we're talking about huge money, right? You know, patent are things like the Pfizer, the Pfizer vaccine, and obviously in the medical profession it's huge, but as well platforms, as well technology companies, there's patents out there. There's actually lots of different patents. But again, so patents are a tool that can be used for building entry against competitors, creating alternative revenue streams. Remember, patent is super important because once you've patent, your business model is all around licensing, royalties, franchising, etc. And that's where the huge revenue streams, you know, come through the patent. What can be patented? New and inventive products that, when compared to existing products in the global market, have not yet existed. Again, it's the idea of being so unique and so novel that it's not out there, it doesn't exist. And what you're creating is that new. Benefits, again, we've just talked about, you know, exploiting your invention, and it's about monetizing it and capitalizing on it, and we're usually talking about huge amounts of money. And again, for example, the most recent I think that everybody can relate to is the Pfizer vaccine. We'd never had the Pfizer vaccine before. The Pfizer vaccine was, I mean, there was just nothing like it before COVID arose and they needed to create it, you know. So that's a really like a basic and very typical example. So we were talking about, in terms of, you know, the contrast between trademark, copyright, and patent. You can even see the complexity, I think, or the level of sophistication for a patent as opposed to a copyright and a trademark. You've got 52 months, the process is generally for a patent. Approximately 15,000 dirhams. Again, that's just for the patent office, but I know that it amounts to a lot more by the time you've added lots of other fees in. And you do need to pass certain requirements and tests by the patent office. So I've been asked to specifically focus on design, because I think a lot of perhaps some of the people that have joined us today and that are live wanted to focus on how do they patent, say, a design. So we're just looking at that for the moment. So design. So what do? It protects the visual appearance of a product. Again, what are the benefits? That, you know, you've got the right to use, exploit, all of that, up to 10 years. What does it do? It deters people from imitating, of course. And then why? Design registrations are a tool to help build and protect the reputation of a unique industrial design. So let me just go on to the next one. Oh, is that all we have on that one? Okay. Rifty, where is the slide on what the actual tests are? No, we didn't put that in. Okay. So there is a number of tests. I can go through those, but essentially there's about 3 tests that you would need to, pass, sorry. Oh, because that's okay. Okay, I won't fluff with this now. So there are about 3 tests that you would need to pass. Tell me what those are, Rifty, based on...
2 are technical and 1 is, it's also technical, but they don't test it. But it's 3.
3, okay. So 3 tests, and they're very technical tests. So it's all around, again, testing how novel and unique, whether it's the design, whether it's the invention, against other, and they benchmark you. So when you're looking at a patent as well, they're looking globally. So as opposed to trademark and copyright, when we were very focused on, what was happening within your jurisdiction, a patent is global. So the threshold even for patenting is a lot higher. The processes are more complex, the procedures are more complex, and hence the actual time to complete is complex as well.
Just curious, how can it be enforced globally? Is there something similar to the Madrid?
Yes, there is, exactly. And there's a name for it as well. I've just it escapes me now, but there is a name for it, and there is a global patent office. Exactly. Yeah. So similar to the NIS classification for trademark and the Madrid protocol for trademarks, there's also that. Sorry, it escapes me. It will come to me, and I'll let you know what that is. But so that's that on and patent. But mostly, look, out of on average, 10 to 12 people that we look at a week that want to trademark, I think once every 6 months we're approached by someone. Obviously, we're not a trademark office. If you go to the trademark office or the patent office, there's plenty more. But in terms of just us as a law firm looking at a small number at a time, patent is every 6 months to 1 year where somebody comes up with something so novel. Whereas trademarking, really, all companies should be thinking about protecting it. Yeah, and it's. I'm not going to say cheap, but it's relatively easy and cheaper than say patent. All right. So I think one of the other things that I really wanted to cover in this presentation was how do you protect your IP from your employees and contractors? Because if you're a tech company, you're going to have a group of CTOs. You're going to have employees who are going to have inside information into confidential information potentially about, and so how do you protect, not from the outside world, but from the people that were within your company? It's super, super important to have, one, inside your employment agreements, very robust confidentiality clauses with your employees, particularly the ones that have anything to do with developing a trademark, a patent, or a copyright.
How
and
do you
then
know that someone might violate this kind of term, or he used this kind of idea? I had a question that I wanted to ask. An idea like Uber, they was the first
right concept. Yeah.
First one built this concept. So another ideas use this, another companies build
Yes.
this idea. And so how you can protect something like that it's not something that you cannot prove that you created, just an idea and something novel. So how you protect something like this idea?
But you can. See, there is enough to protect it, right? There actually is. Like when you say, it was just an idea, they would have protected it, not when it was just an idea that wasn't developed, but as soon as they had a developed idea, they would have immediately tried to protect that. And the way to know, I guess, if your employees are doing it is generally the information leaks. So in my experience, at any time we've seen anybody jump from one company to another competitor company, and that competitor has launched something that's too similar to what you're doing, and that specific individual was there, then you could file this claim. And we see this a lot.
Source code and how it's written. It's about the idea. He might wrote everything from the scratch. He just used the app as a user.
Correct.
He saw the concept and he built it with another source code, so he didn't validate any
Right, because the source code, yeah. But if it's
not
too
about the source
similar,
code, it's about the idea itself, because it's like there's 6, 7, 8 startups are doing the same thing. So why Uber, it's $1 billion company, couldn't protect these kind of concepts? That's my question. It's not someone's question.
it's yours, yeah. Yeah, look, there is always an element of how much protection you can have, right? But I guess it's the idea is if you've come in first, you've developed it, you've put trademark, patent, IP, copyright, all of the protections you can in the classes that you can. Look, I guess ultimately, can you bulletproof 100%? Not really, right? I mean, we see it all the time, not 100%. But when you're on a mission, there is no competition. Uber would have looked at all its competitors and said, all right, go ahead, try. But we've got something so robust here that even if you tried, you're not going to make it like we are. And so, yes, there will be law cases, suit cases, and they will win them, and they'll get IP. I mean, just recently there was somebody telling me about, 2 huge competitors that would trying to take each other out basically for IP claims and whatever. And it happens. And we see it all the time. But and there are damages and things like that. But at the end of the day, it's always to an extent, right? Can you bulletproof 100%? 100,000%? No. But
to add to that, I guess it comes down to the power of the brand at that point.
Exactly.
It's the brand that's the one that's a stronger brand is the one that's going to push through. So, it's like saying, like your question is like saying, McDonald's, they're a fast food chain. Somebody else went and opened another fast food chain. So
that was so similar in nature.
Yeah, similar in nature.
Yes, but can they compete with McDonald's? Yeah, no, right?
But isn't it generally like that it's nearly impossible to really patent any tech idea? I mean, an example of Uber, how many other companies have copied the exact business model and the look and feel of the app, I think. So
you can't copy exactly. If you're too similar in nature, you'll be stopped. You won't even be able to register or protect your interests if you're too similar to a company that's already registered. And when we're talking about patent, there's much more level of scrutiny at that point, right? So patenting, because you're so novel, at that level, like, I mean, McDonald's, for example, their flavors are patented. The KFC, it's all patented. You can't get the exact recipe so specific, like in terms of ingredients and the amount and how they've processed and put it together and whatever to come out with that. I mean, people have tried, right? But can you ever get the exact as KFC? No. So at a patent level, there is that scrutiny and it's just too hard to copy identical. You're right, yeah. Absolutely.
But innovation is like the combination of ideas. So you take something and then you combine it. And I think this is really hard. This is like impossible to patent, right?
So, yeah, exactly. A little bit difficult. It needs to be concrete. Whatever your patent needs to be concrete. So there needs to be a defined and identified procedure. You're going through levels of rigorous testing on how did you arrive at this patent? What did you do and what process or procedures, what ingredients are making this so novel? And the level of scrutiny, by the time you get to patent, you're really protected, and your competitor is not really going to be able to ever do anything so close to you, right? Because it's that novel. If once you pass that after 52 months and you've got this as a patent ID, you're not likely to have a competitor to be able to get close to you. But innovation is a little bit different, right? Because as I said, you might take a source code or you have a source code that's different from the source code that was copyrighted and you have a similar innovation. You could still go and protect that, So
Uber Korea was a good example. Okay, maybe the technology behind it is different. The coding, the interface might be slightly different, but the functionality of it
is exactly the same. Exactly. Yeah, exactly right. But is their back end the same? No. Right? But yeah, they're in the same industry doing very similar things? That's correct. But Uber couldn't take out Cream and whatever and say, you're doing what we're doing, therefore you stop to do it, right? We've still got Uber, we've still got Cream. But the back ends are different. Whatever their source code or development or their platform or the function and everything that they've protected is obviously different, and that's why they're able to register. Yeah, so if we go back to, sorry, on that point about the contractor, so what you want to do is, and what the trademark officers will actually mandate for you to do is, if you've got a CTO, for example, that's designed your platform, and you've gone to copyright, say, the source code of the platform, you will get the technology officer to sign a waiver and to assign any right and any future claims whatsoever that he might potentially have in whatever he's developing. So, because you'll have lots of employees go, but I developed that for them. That's not the company's, that's mine. I worked there and I developed it. But you were developing it for the company. But it's not enough just to say, okay, you were an employee and in your employee capacity you did it, and therefore it's for the company and you can't go and copyright it. What you want to do is specifically have from them a written waiver, an instrument that says, in my employment capacity, I developed this technology with this source code, and I waive all and any rights in this now and in the future, right? So that you can protect yourself from your employees and the contractors. And the same thing with the developers. So we've got a couple of cases at the moment where we have startups that were obviously bootstrapping and contracted out a development company to create, you know, the website, the platform, everything, user experience and all of that. And of course then they got a bit of, you know, in a sticky situation. They couldn't pay the developer. The developer said, right, well, thanks very much, but we're not handing anything over to you. All of the IP remains with us and that's ours. You've not finished paying. You've not fulfilled your obligations. We don't need to, you're in breach. We're not. Until you've paid, IP belongs to us. Startup came to me and said, well, can the developer say that? And I said, well, what's in the contract? Because have you specifically stated with this developer that they should not be able to use it, even if you were paid like for a certain period of time, or to wait, or not to be able to claim any of that? And in fact, when we went back to the contract, what we saw, so I must have pressed something. Yeah. So what I found in the developer agreement was specific clauses that stated if the startup was in breach, that the developer would be able to retain the IP and to keep it, and after a set period of time, then go reproduce it, change it, do whatever they wanted to do to the nature of it, because it belonged to them. And the startup signed that. Tricky to get him out of it. So what you always want to do is foresee that that could be a potential and build those into your contracts. You always want to mitigate risk. And mitigating risk is foreseeing what are all the potential possible scenarios, working backwards and drafting and building those into your contracts with the developer and with the employees. Make sense? Any questions?
Yeah, but I'm waiting you to finish on it.
Perfect, no worries. I actually think that brings me to the end of the slides. Yeah, fantastic. I don't know, with our details are not on here. Oh, yes, they are here. So if you've got any questions, post this for everybody who's looking out. This is the email. I'm not sure if they can see that, right? Yeah. So email, website, and phone. Put the mobile there.
What stage of startup we should do all this legal activity? What is the first thing at 2 months old startup? Do any paths? What is the most critical legal steps we need to do first?
My suggestion is, I mean, if you're only 2 months old, you're still developing your idea, your concept, your brand, your color, your look, your feel. It might change. You know, what we started with, say, you know, in our 2 months of business as opposed to a year in was a little bit different. So when you've got something that you're set on, then trademark it or copyright it or patent it, whatever it is. Yeah. So, but if you're still developing still in the idea stage, you're still perhaps changing your colors or your look or your feel. I mean, we've seen so many businesses go through those transitions. Wait till you have something a little bit concrete, because as I said, I mean, at the end of the day, you're looking at 9,000 dirhams at least for a trademark in one class. 5,000 of that is for the trademark registration filing fee, then you've got POA costs and official gazette costs and lots of those things. So you want to at least, you know, be a little bit concrete on what you're going to trademark or copyright.
Second question is, how long is copyright valid?
Yes, so copyright is valid for 50 years, as I had on that slide, and trademark is for 10. with the option of, obviously, if you've not used it for 5 years, then somebody could object to that filing, and the trademark office would need to sort of entertain any objection. But yeah, 10 years under trademark and 50 under copyright, and patent, I think it was 10 as well.
And will it be a worldwide protection?
For the trademark? No. So trademark, you need to register individually in the jurisdictions you want to be protected in. Yeah. So if you, just to be more clear, if you trademark in the UAE, it doesn't mean you have protection across the Middle East. So it doesn't mean that you've protected in Saudi or Bahrain or Qatar or Egypt or Jordan, any of the Middle East.
But if you, so you said, I understand, so if you want to protect yourself in more countries, you can do it via this protocol?
Yes.
That's probably a separate application?
So no, it's one application. It's just that it's streamlined, and it's just that when you go to this platform, you can see all of the jurisdictions, and you can see what the fees and the procedures and the laws are for those jurisdictions. So they've just unified it. Unified.
So you just have to select which jurisdiction?
Yeah, you can just have a look at what the trademark laws are and the compliance in the different jurisdictions, and then get a cost of what it is. Yeah, but you still have to pay individually for registering it in each of them. Yeah.
Right, they just make it as a...
It's just more of the unified, taking a unified approach to it, yeah.
And you also mentioned that for the copyright, you need to submit a written instruction how to use the system.
Yes.
So, also regarding the timeline, at what point would you say does it make sense to also submit the copyright, as especially in the beginning, the system is always so agile and constantly changing. So even in the first few years, I think you always add or subtract functions.
True. But once you've got like a source code for the platform, once you've got a clear idea on how the functionality is, you can copyright it. Copyright, it's not overly expensive anyway. So once you've got that and you want to protect, I think it's easy and quicker to do. So I do it quite quickly.
Isn't it unfair for bootstrap startups to spend so much on patents and spend almost a year?
I mean, what can I say? I don't make up the laws, the rules. I don't make the fees. I don't do any of that. Yeah. Unfortunately, yeah. But remember, particularly if you're going to be creating a patent and protecting that idea, and if it is actually patentable, the return of your investment is likely to be huge. The revenues that you generate, I mean, when I see some of the startups that we work with and some of the inventions that they're trying to patent, these patents are so sophisticated, and the revenues they're going to be generating through licensing, franchise, and royalties far exceed the amount that they've invested to patent their concept. And that's the point, isn't it?
Daniel's telling you this session is very interesting, and he's asking about recording. Yeah, it's recorded. So.
Thanks, Daniel. Was it Daniel or Danny? Daniel. Thanks, Daniel. I'm glad you're enjoying it.
Trademark are applicable to jurisdiction of registration. What about copyright and patent? Does it exist any jurisdiction limitation?
So the patent is global. So when they do the check and when they scrutinize, it'll be like a test that is globally recognized, as opposed to the trademark, which is very local and very jurisdiction based. And same thing for copyright. Copyright's similar to trademark. So it's not a global protection, but patent is.
That's pretty much. Very good.
Great. Okay, fantastic. Any other questions? No? All good? Yeah. All right,
I
fantastic.
already dropped my email, so for everyone, if you have any questions, here's the emails of
Legal Circle.
So I'll be more than happy to put you across if anyone need anything. Yeah, this is from our side.
Excellent. And maybe you can ask them what other topics, because I'm assuming most of them are startups as well.
I have another topic that I'm a
That you need to any other topics, because we'll do these more often.
For investments, like this is.
Oh, that's a hot topic.
Yeah, exactly.
Yes.
I was like trying to ask a couple of questions, but it's out of.
Right, out of context today. But no, we can definitely, definitely have
so
a.
You can ask like what kind of topics people are interested to have their own.
Yes. Absolutely, absolutely. So for all of the startups that are on this call today and who've benefited from this, there's lots of other very interesting and I think relevant topics for you. So just to make sure that we are speaking on topics that are relevant to you, if you can drop down and Ahmed can have a look at those, you know, what topics that you want to hear about, whether it's term sheets, fundraising. Yeah, I know that's a really big one. It's a hot topic always. Scaling, just obviously we talked about IP protection today, but maybe employment laws, dealing with staff, employee issues, that comes up for a lot of the startups as well, particularly around the non-compete clauses. So, you know, if you just brainstorm out any, I suppose, issues that you've, and obstacles that have arisen for you along the way, and jot them down, and yeah, happy to have a presentation on that. Too easy.
I put my email address, so anyone reach out to me, I'll be more than happy to arrange that.
Fantastic, very good. Excellent. All right. So if that's no more questions, I guess that brings us to the end of this session.
Marco, thank you so much. Very interesting, useful, and clear session. Keep going.
Thank you, Marco. I'm glad you enjoyed it. Excellent. All right. Thanks so much.
All right.
Thank you.
Thank you.